A very good morning to one and all. I, Lori Chatra, on behalf of the IILM University Gurugram, extend a very warm welcome to all of you. Today, the IILM Law School has organized a workshop on resolution of dispute by mediation, including family dispute. Mediation has often been recognized as the fastest growing mode of alternative dispute resolution. It allows parties to relook at mutual interests and come up with innovative solutions through an interactive and facilitative process. Now, I would like to invite our Vice Chancellor, Ma'am, Professor Dr. Sujata Shahi, to welcome our esteemed guests and panelists for today's program. Please, ma'am.
Thank you, Laurie. Good morning, everyone. Our Chancellor, Dr. S.Y. Qureshi, Pro Vice Chancellor, Dr. Kakoli Sen, Director, Mr. Sanjay Subarna, Dean, Dr. Asha Verma, colleagues and dear students. It is indeed a matter of honor and pride to welcome Hon'ble Justice Manmohan Sarin. He is also part of our board, and Hon'ble Justice Manju Goel for the workshop on resolution of dispute by mediation, including family dispute. The concept of mediation is ancient and deep-rooted in India. From Lord Krishna mediating between Kauravas and Pandavas in the Mahabharata, to family elders resolving domestic issues, to the resolution of disputes at the community level through panchayats, there exists a strong culture of mediation in India. With the passage of time, there are certain statutes which provide for mediation as a mode of settlement of dispute between the parties. I think mediation is a way which helps the parties think outside of the box for possible solutions to the dispute, actually broadening the range of possible solutions. Interestingly, due to the unique nature of family law in India, mediation is especially helpful in family disputes. Family matters involve not only laws and facts, but also feelings, which also make mediation an effective tool for resolving such disputes, as it focuses on non-coercive and consensual process. It is now common practice within family disputes for mediation to take place during their disagreement. Always I teach organizational behavior, and during my teaching, I used mediation as one of the tools for organizational conflict resolution. But today, I get this opportunity to listen from eminent personalities of India about mediation and its effectiveness, not only in organization, but in family and everywhere. Without taking much of time, once again, I welcome our esteemed speakers to IILM University. And I hope we all will have a great learning and great knowledge from our esteemed speakers. Thank you very much. And once again, welcome to IILM.
Thank you so much, ma'am. Now, we would be starting our session. But before we start the session, I would like to inform the participants and students that whoever has any question, they can post their questions at the Q&A box and they can raise their hands. We will be taking it up at the end of the session. Now, I would like to invite our first eminent speaker for today, Hon'ble Justice. Later, he practiced as an advocate in Delhi High Court and Supreme Court. He was also a senior panel counsel of the Union of India in a variety of matters in arbitration and in writ jurisdiction. His passion for law made him play a major role in setting up the Delhi High Court Mediation and Conciliation Center. While he was Lokayukt for the National Capital Territory of Delhi, he also functioned as the chairman of the All India Committee of Lokayukts, which drafted the Model Pramukh Lokayukt and Up Lokayukt Act. He has been rated by the Lieutenant Governor of NCT of Delhi as the best Lokayuk Delhi has ever had. He is an empaneled arbitrator with the Indian Council of Arbitration. Welcome, sir. Looking forward for an enriching and great learning session.
Thank you, Lore. Dr. Qureshi, Chancellor, IILM, Mr. Anil Rai, Founder, IILM, Dr. Sujata Shah, Vice Chancellor, Mr. Sanjay Subarna, Director, Dr. Asha Verma, Dean, and RTG. It is indeed a pleasure to be with all of you. Of course, there is bonding between us, and as Anil said, we all happen to be quite some one way or the other associated with St. Stephen's. Apart from that bonding, this subject has been dear to my heart. Today, I just want to begin by giving you a broad idea of the alternate dispute resolution method and the need for it. Now, you are aware of some of this. We have an elephantine backlog of mounting arrears. This has plagued and clogged our judicial system. I was looking at it, even despite judicial reforms, legislative enactments, getting a number of statutes which were unnecessary off the statute book. As of 2021, we have 69,956 matters pending in the Supreme Court, 56,69,960 matters in the High Court across the country, 4.02 crores in the district and Talika courts. Out of the above, this is the disheartening part, 91,78,739 cases are more than 5 years old. And 3.12 crores are more than 1 year old. Now from this you can get the magnitude of how many persons are waiting for justice to be delivered. This is not the day today to go into the causes or for the judicial delays or reforms or lack of judicial infrastructure. But let us look at it. How do we find other alternate methods to take care of this perennial problem? Another thing we need to focus on is, with increased legal awareness, the number of institutions is going up. And you know, the Indians by nature, Indian citizens, are very patient. Despite the distress which may come for in not getting immediate relief, faith in judiciary is still overwhelming. And so people still are going to the courts in the hope of getting justice. So excess of justice is being sought by people again and again. There is another aspect to it, but if this is a situation is allowed to deteriorate and we don't take corrective measures, we also run the risk of frustration and strong arm tactics, or result in exploitation of the marginalized and lawlessness as the last resort happening. How long would a person wait for justice to be delivered? If he does not get it, he would rather engage persons who can assure him a solution. So that is the thing which we have all to avoid. Apart from that, there is an economic aspect of it also. Pendency of cases affects global perception of doing business in India. The overall ease of doing business has improved to the rank of 63 of 190 country out of 190. Earlier it was 131 out of 189. Ease of doing business index as per World Bank status. This is as per World Bank statistics. Now see this, the rank for ease of enforcement of contracts in 2016 was 178 out of 189. which has improved to 163, marginal improvement. So imagine we fall at 163 number in the entire list of countries abroad for enforcement of contracts. Why would people like to come to India and do business? We talk of India being the hub of many things, but this is still the situation. This has to be corrected. Despite judicial and legislative reforms, we have not been able to make significant headway. It is in this context that the existence of an effective ADR mechanism in place is vital to achieve the goal of 1 trillion economy that we very often talk about. We need to develop suitable infrastructure for arbitration as well as mediation and conciliation. More importantly, we need to change the mindset of parties who rush to court without availing of the ADR mechanism. Now I want to pause here and make a reference to other jurisdiction. Take USA for instance. Only 30% of the cases disputes go to courts. Imagine 70% of them are resolved otherwise. So this is the potential of ADR. At least that is the maximum limit to which we can look at tapping. A large number of them are settled even after institution, but before the matter goes to trial. This is where pre-trial evaluation and assessment is done. In our judicial system, we need to resort to Order 10, CPC, read with Section 89. Now, here, I can tell you, the statutory enabling provision is there. If you all know, Order 10, Rule 1A provides for recording of statement of the parties to see what they have admitted, what are the allegations they are not accepting, and at that stage, to say that this is what is admitted, this is the dispute. And then recording that statement, the judge narrows down the controversy. At that point of time, 1A provides that, look, you see, if there are elements of settlement, then you refer it to one of the 4 modes prescribed, that is mediation, arbitration, judicial settlement, etc. But in practice, it doesn't happen. So this is a provision which our courts, and the remedy would lie in the courts during the, we are taking steps in a sense. Judicial academies are again and again during their seminars and orientation of the judges, requesting them to invoke these provisions. Now coming to today, I wish to give you some insight into mediation and conciliation process and the difference between them. The essence of mediation, Dr. Sujata Shahi had very aptly traced the origin to Parva Pandava disputes, Sri Krishna, and saying how culturally it is rooted in us. Yes. And now it lies in a neutral, working with the parties and helping them find a lasting solution to resolve and end their conflict. Now the essential difference is, in mediation, the focus is not on adjudication. You do not decide who was right or who was wrong. Of course, who's right or who was wrong will affect and impact on the settlement that is arrived at. We don't ignore that. But that is not the central part. We don't start by saying, you are in breach, you are guilty, you are doing that. That is not the way mediation would begin. It's as in the purpose is to avoid adversarial adjudication. Gandhiji said it is a great service to join the hearts of those driven asunder. Now, why is it so? A good settlement is worth more than a good judgment. It is quicker with no appeal. The resolution ends the strife and polarization and bitterness by bringing them together in a lasting solution. It is a win-win situation for all. There are no appeals. I would like to dilate a little on this. Unlike a court judgment, you work on it, you lead evidence, engage good lawyers, ultimately have a sense of victory. And you gain maybe a money decree or special performance or whatever it is. Next problem becomes execution. Now you want to execute that decree, the other party will come up with several objections to execution, apart from an appeal being preferred against the judgment. And if there has been some procedural loopholes left or violation of principles of natural justice or time not granted to lead evidence, the appeal court can set aside the judgment. So you are in another merry-go-round. So that litigation part is avoided. More importantly, the bitterness and polarization, strife, which is there, is avoided in mediation. Because in mediation, parties themselves reach a conclusion. The role of a neutral is to lead them on and help them find a solution. Manjuji will dilate at length on this, the techniques for it. It sounds simple, but it is not so. There are various methods of doing it. The essential difference in conciliation and mediation. You very often hear the term conciliation. Broadly speaking, let me say, in conciliation, the conciliator adopts a proactive approach in finding and offering solution, bordering on intervention. I have used deliberately the word bordering on intervention. He will try to not impose, but at least try to tell them this is the right thing to do. But a mediator does not do so. He only suggests, would it not be better if you do this? Would you like to consider this? While the role of a mediator is that of a natural neutral person, helping the parties to find a lasting solution. It is more in the nature of an impartial neutral facilitator. It is a negotiation carried out with the assistance of a third neutral party, that is the mediator. The mediator or conciliator, in contrast to the arbitrator or judge, has no power to impose an outcome on the disputing parties. This is important. In mediation, you had any Shimla talk or whatever it is, you fail. And the reason for failure are not to be reported. The process is confidential. Despite the lack of teeth in mediation process, the involvement of a mediator alters the dynamics of negotiation. Depending upon what seems to be impeding an agreement, the mediator may attempt to encourage exchange of information, provide new information, help parties understand each other's views, concerns. This is extremely important. A neutral in his own subtle way brings about an understanding in a party about the concerns of the other. Let them know their concerns are understood, promote a productive level of emotional expression, deal with differences in perception and in trust between negotiation and constituents. Help negotiators realistically, give them alternatives to settlement. This is important. Bring it to their home. If you don't settle, these are the alternatives to you. Where would you be headed? Learn to listen. Now, these are the essential qualities of a mediator. And that's why at times it is said, judges over after some period of time do not end up being good mediators because they are used to having giving their decision. They are authoritative pronouncements. They are used to it. So they may not be the best mediators because you need to only listen and slowly bring them around. At times in mediation techniques, you listen to both the parties separately before you hear them together. There are immediately during the mediation process, it may not be right to disclose what the other party is saying about the other one. So at times the mediator acts like a filter or a blotting paper. All the acrimony or wrong things which are being said, he'll absorb and not pass it on. Pass on only what is essential from understanding of this party's perspective. Focus in the ADR method of mediation and conciliation is not in finding the party in breach or default, but finding creative, mutually acceptable solutions which would maintain and retain healthy relationships. Advantages: it's the most cost-effective method. Mediators as of today are still not that expensive. It is a win-win situation for all. Confidentiality in mediation and conciliation. Failure in mediation and conciliation is not to affect the rights of the parties or pending litigation. The conciliator and mediator simply report failure without any details of negotiations, lest it may prejudice the rights of the parties and may inhibit the parties from disclosing candidly all the factual aspects. You pause for a minute here. Why do we have this clause of confidentiality and the provision regarding not reporting the cause of failure? At times one may wonder, if the court knew the cause of failure, perhaps it could exercise. No. The objective in mediation is of a at a higher level, which is to get the parties to fearlessly, candidly have their say. That is far more important than anything else, because that will end the strife, that will bring about an understanding between them. Mediation and conciliation process. Generally, the mediation starts with introductory remarks by the mediator. Then a statement of the problem is made by the parties, and the mediator gives his opening statement. He gives each side an opportunity to tell their story uninterruptedly so that they can crystallize their issues and give the mediator more information on emotional state of each party. You will hear a lot from Manjuji on this, how a mediator judges what is their emotive state, especially in family disputes. Information gathering. The mediator will ask the open-ended parties open-ended questions to get to emotional undercurrents. This is very important for a mediator to understand the emotional undercurrents. I'll give you an example a little later on this. Mediator may repeat back key ideas to the parties and will summarize often. This helps the mediator build rapport between the parties, especially when facilitative style is used. Mediator tries to find common goals between the parties. Bargaining and generating options to reach an agreement. Now, I recall I said I'll just give you an illustration, especially in family matters. What was happening was, between two brothers, one of them was in dire need of money because of his daughter's wedding coming through, and they had some piece of property and land which they wanted to sell. It was joint property. The elder one would not agree. And he says, no, price is not right, I am not doing. So the other fellow said, all right, I'm filing a suit for partition. Now, suit for partition would take all its time. It would have not served any purpose. So mediation process was started. And I happened to be at that time in charge of the mediation center. So they had come there. So mediators were trying, and at that time, I asked the parties, I said, what is your problem? So when we talked to the mediators, then informed me, sir, this fellow is very unhappy, the elder one. So it turned out the motive and undercurrent was that when the younger brother, somebody got married and his elder son or other one got married, this fellow had not given him due respect to the elder brother. And he was not made to do, you very often you have this milni for the elders as the milni. So that was not done. Now this was deeply rooted. It remained buried. And this one won't give this as a reason. But when you probed, so we said, look, I told him, you are the elder in the family. This is how it erupted. I said, you are an elder in the family. The younger one is his daughter is to get married. Should you not be helping? You are like the father figure. He said, what father figure? This fellow did not let my milli even be done. So this is how it erupts. So what is the undercurrent? Undercurrent was removing this insult. So in the separate session with this man, I told him, look, you have committed this folly. You better make sure that you unhesitatingly, with your open heart, tender an apology to him and make good. So this fellow then brought his wife and himself, and they both apologized. And can you believe it? With this emotive thing gone, the man was willing to sell. And he says, all right, we will sell it. So at times you don't know where, what is the undercurrent which is stopping it. Mediation and conciliation process, though appearing simplistic in nature, requires skills and expertise. It requires intensive training in communication skills. Making of the opening statement, listening to parties, giving their versions, and vent to their feelings. You see, if you do not have patience to listen to the parties, you cannot be a successful mediator. You have to allow them time to vent their feelings. You may, as a judge and a lawyer, get this tendency, he's talking irrelevant. Especially we get it. I say, what has this got to do with that matter? This is not relevant. It's of no consequence. This is what we end up saying very often. No, but when you don the robe of a mediator, you have to accept, let me listen to this fellow, let me put myself in his shoes and then understand the problem. Followed by single sessions, joint sessions, brainstorming sessions, and then there are techniques for breaking of impasse. Manjuji will refer to them. I am not going in details. Mediation or acting as a filter, I told you. Qualities of a good mediator and conciliator: good listener, have eye contact, body language, non-judgmental, gaining confidence of parties, and I call them 3 I's and 3 P's. The 3 I's are integrity, impartiality, and ingenuity. Please make a note of this. A mediator must possess this: integrity, impartiality, and ingenuity. And unless he has this, he will not enjoy the confidence of the parties. Parties must feel reassured that here is a mediator who's going to be fair to all of us. For that, integrity is important, impartiality is important. And what is ingenuity? Why did I say ingenuity? Would anyone of them like to answer? Ingenuity, because the essence of mediation lies in finding innovative solutions. That's why the ingenuity part is there. The 3 P's would be patience, perseverance, and persuasion. Patience, to hear and address all concerns and emotive issues. Perseverance, not to give up on intransigence or acrimony exhibited. At times during exchange, if they have a joint session after the single session, you find parties have so much acrimony. He says, this fellow is useless. He is a treacherous man. He is a cheat. And the other fellow says, not he is calling me a cheat. He is so and so and so and so. He'll say the vilest things for him. So at that point of time, firstly, you have to avoid that stage doesn't come. But if it comes, that is where your perseverance is required. Persuasion, leading parties to a solution. That is slowly suggest what is an ideal solution. Do you think this is a solution? What do you think what would be a better solution? That's how we go about. Now, for instance, let me give you the simplest example on creative solution. This is a very proverbial old one. Maybe you have heard of it. You know, an old man, a man died. He had 17 camels. So what he did was, he said, half of them I will to my eldest, 1/3 to the middle, and 1/9 to the youngest. Now, how do you divide them? You can't slaughter one of them, these camels. So if half is to go to the eldest, out of 17th, what do you do? 1/3 are to go to the middle. How do you do? So what he did was, the part of the will said, in case of problem, go to my old friend. They went to his old friend, and the old friend said, all right, come. He says, deceased was my old friend, and I want to come with you people. I want to add my own camel to you. I want to gift you a camel. So what he did was, the kitty was 17, he made it 18. Now see what happens. Half goes to the eldest, 9 gone. 1/3 to the middle, 6 gone, 15. 1/9, 2 to the youngest, 17 gone. And then the fighting persons realized what was happening. And they said, I take back, they said, no, uncle, you take back your camel.
मैं ना एक ऑनलाइन वेबिनार में हूँ, मैं आपको वो वेबिनार खत्म होती बात करूंगी.
मंजू जी मुझसे कर रही हो किसी और से? अच्छा. So now what are the kinds of disputes which are ideal for mediation? Commercial transactions, family and matrimonial, consumer disputes, motor accident, tribunal disputes, traffic offences, of course. What can't be resolved by mediation, or one may not attempt even, complex legal or constitutional issues. For instance, let me put it, I personally thought, where there has been heartfelt such litigation over a period of time, or the Babri Masjid issue, that was hardly possible to resolve it with mediation. Or mediation would have been given a lot of time for this. But you can't have a solution on a complex issue like that, where title is involved, in 2 months or 3 months. And what I would recommend is this. While introducing me, you had referred to our setting up the Delhi High Court Mediation Center, which is true. We have set it up, and I am told it is functioning well. We had trained during my time, so Manjuji, by now there would have been many more. Over 350 mediators had been trained. Now the number would have gone up. We had regular training courses we conducted at Manesar. We are training people in mediation. So I don't know whether Punjab High Court has similar one in Gurgaon, or district center mediation are available. What I would recommend is, Dr. Sai, you consider those of students who are interested during their internship, they can be placed with the mediation center for short terms.
Yes, sir, sure.
So kindly consider this. If you people get it in Gurgaon, ideal. Otherwise, Manjuji and myself will try to put you in Delhi. There we have lots of people.
Okay, sir.
I think I have taken my exact time, more than 1 hour or so. I should not come between Manjuji and you, because this is where mine was general, give you a broad idea about mediation. Now it is on to Manjuji. And I must, before we start, tell you something of interest. You know, Manju's and my bench came to be known as the Saint Valentine bench. And there was a reason for it. What was happening was, in those days, there were these runaway marriages are still here, but lots of young people who would elope, and the practice was file an FIR. The young boy who's 18, 21 would be arrested, kept in Tihar, and the young girl taken back to the village or the house. So that's the time we both decided, irrespective of the age, we would release them, grant bail to the boy, and then call them in court. And if the girl was more than 16, we would say, and she was Hindu, we would say, she's in the marriageable age. Marriage can be declared void, but has not been declared void. So go ahead. And interestingly, given the slant of press reporting, I was abroad, I still remember Manju calling me, what has happened? See, the press reported Delhi High Court modifies the age of marriage. This is not what we had done. So we lived with it, but we enjoyed it. That was a very good tenure with you, Manju. I still cherish it.
Thank you. I also recall those days, the reporting of the newspapers. And I was challenged by one very eminent Supreme Court judge in one tea party when she asked who wrote that judgment. So briefly, I explained what the Hindu Marriage Act said about the age of the marriage and in what situation marriage is valid and when it becomes void and when it is voidable. So quickly, on a cup of tea in a party, I had to explain all that to her ladyship.
Well, my reaction was, forget it. We are here to give judgments. we have written it. It's authored by me. Don't bother. Yes, Manju, start.
First of all, let me thank the university for giving me this grand opportunity of speaking to students on mediation. Justice Sarin, Dr. Qureshi, Dr. Verma, Dr. Sujata Sahi, Dr. Sonchatra, Mr. Anil Rai and Subarna, as well as all the students, and if anybody else is participating, they are most welcome to today's session. So I owe my experience to mediation mostly to Justice Sarin. Even before I came to Delhi High Court, I was in Delhi State Legal Aid and Advice Board, where we did a lot of mediations. Without formally calling it mediation, we used to call it the Family Counseling Center, and we did a lot of work there. But then giving me this formal recognition of being a mediator or a mediator trainer, I am deeply indebted to Justice Manmohan Sarin. And there are other reasons to admire him for many of his internal qualities. For being a good judge and to be more than good, I think he was a very, very bold judge. So that gives courage to the bench partner, and very often I have been telling the stories of his boldness to the trainee judges in the Delhi Judicial Academy and to the National Judicial Academy. And on various occasions, I interact on how he handled sensitive situations, not necessarily legal situations. But very often we come across very sensitive situations in court, and you have to handle that. not with the help of law, but with the help of your acumen, God-given acumen, which no one can teach you. Now, after this grounding, let me tell you why we have chosen family mediation to talk to you, because most of the matters referred to the mediation center are matters relating to family. And perhaps the first encounter of a dispute for a person may be a family related issue, may not be his own family, God forbid. But even as a lawyer, he is most likely to get his first matter related to some family dispute somehow. Now, I have always considered family disputes to be different from other kinds of disputes, because family disputes affects a person in a way which no other dispute affects. The home I compare with a fort, where from where all other battles can be fought. But if you have a fighting going on in the fort, imagine what happens to that side. So when a person returns home after all days fatigue, he hopes to go back to peace, his wife, his children, or his mother, father. But think of a person who thinks that I'm going back to a battlefield. So he is likely to lose all other battles in life. So this is a very sensitive matter. It destroys the man. In fact, man or woman, whoever is involved in a family dispute, his very life is in severe danger. And in most family disputes, law has to take a back seat, as that story we have just heard. The dispute lay somewhere else. On paper, it is something else. The dispute is not a legal dispute, but its appearance is that of a legal dispute. So it's up to the mediator to go deep and find out what is the dispute. When I go to judicial officers, I give them this example of the movie Abhiman. How many of you have seen this movie? Abhiman, Jaya Bachchan, Amitabh Bachchan. Raise your hand if you have seen. And I invite the judges to divide themselves into two groups. One filing the case for Jaya Bachchan, or Uma as she was in the movie, and the other half filing a suit for Subir. And they come out, I said, now come out with the grounds on which you will demand a divorce. And they drop, fantastic grounds, an unbeatable case on both sides, totally unbeatable. Because we have rulings, and the rulings are very important in court. For example, if the husband does not come to the wife when the wife delivers, the ruling says it is an act of cruelty. So if now the husband did not reach the wife when the wife delivered, the husband knew the wife was about to deliver, the child even died, the husband did not visit. There cannot be a better case. Only citing this example means a sure case for divorce. In addition, the husband is seeing another woman. The husband is not going to work. You see, and similarly for the husband, I don't want to enlarge it here. Similarly for the husband, the wife leaving home without telling the husband is a great act of cruelty. Or not telling the husband when she becomes pregnant is an act of cruelty. So all these are, judicial rulings. So if you add them up, both the parties could sue for divorce and were sure to get one. And then I asked, was it a case for divorce? So one has to discover, because Abhiman is the name given there, meaning thereby one side is already told the cause of the dispute is Abhiman. The other side, the tremendous guilt that the wife is suffering from, the sense of guilt in the wife, that has to be discovered. That was discovered at the end. And when that was addressed, the resolution could take place. I'm sorry, the younger generation may not have seen that movie, but I will request the university to have an official screening of this movie for anyone who is trying to become a mediator or trying to understand what mediation really is. Now, between brothers, one very good example we have already had from Justice Sarin. I always keep it in mind. There is another good story. Good story means real life experience of two brothers falling apart. This was the case of sacrifice by an elder brother who left his own education and proceeded to educate the younger brother because the father died untimely. So the younger brother got good education, became an IAS officer, married a modern woman. And then the dispute, when the dispute started, the brother said, I won't share in the family property. The elder brother would say, no share, it is I who have been maintaining this. No share. And so now this is again narrated by a judge, another very senior judge. Justice Pasaya told us this story in one informal meeting. When he called the parties for an attempt to amicable settlement, he was not a trained mediator. But then, you know, sometimes it is the natural wisdom of a person who is a judge, or sometimes I very often attribute the success to the destiny of the parties. Now, while talking to them in the chamber, it turned out that the elder brother wants the wife of the younger brother, who is now a modern woman and doesn't believe in those old style etiquettes, to cover her head with her pallu when she is in his presence. And she would say that, well, this is a useless concept. I don't believe in this. So the elder brother wouldn't even talk to them because he considers to be minimum etiquette. Now, on the request of the judge insisted that she must cover her head, at least for the sake of the judge. Let her cover her head once. And the moment she brought her pallu over her head, the elder brother started crying. He said, this is all that I was needing. The little respect of being the elder one, recognition of the sacrifice that I have undergone in order to educate the brother. All that I want is to be recognized as a senior or as an elder person. So the core of the dispute was not greed for the property, but it was the need to be recognized as the elder one, recognition for the sacrifice that he had undergone, and an expression of love. So this is just one example. There are hundreds of examples between brothers. In one case in Delhi High Court, the younger brother, again this dispute, you know, between elder and younger very often takes place when the elder brother is more than a brother. Maybe a mentor, a father figure. And here the elder again looking only for a little respect. And the mediator said, can you come and touch the feet of the elder brother? Both refused. The mediator then proceeded to touch the feet of the elder brother to just ask for forgiveness. When the mediator started bending down, the brother said, okay, let me touch my elder brother's feet. And imagine, as the younger brother bent down to touch the feet of the elder brother hugs him, and both crying and crying. So you see, if the ice is broken, it's not more difficult to handle the legal issues. Now, what happens in a family dispute? I don't know how much time I have, because in order to bring out the point that I want to make, it's essential to stay with the subject for a while. You see, in a family dispute, it is not a dispute between two persons. It is a dispute that envelops everybody, the brother's wife, the brother's son, brother's children, the mother, and everybody gets involved. Everybody has a say, everybody is influenced, everybody is affected by the dispute and by the solution. Indian marriages are very complex. It's not between one man and a woman. And it's not easy to get into a marriage, and it is not easy to get out of a marriage, as it may be in the West. Marriages are very expensive. And when the matrimonial alliance takes place, very often the alliance is influenced by the other earlier alliances. You see, to whom is the elder sister married? Who is the mama of that person? All these matter. And once this marriage takes place, this marriage is going to influence the other marriages. So getting out of marriage means a lot of expenditure made by the father going down the drain. So then if the child comes, then it is all the more essential to stick on to the marriage. So it is not easy to say, get out of the marriage if you don't like the man. Or if the man has hurt you, get out of the marriage. I cannot believe that she has been bearing this marpeat all this time. But this goes on. In fact, it happens in, you will be surprised to know what percentage of women believe that the man has the right to beat her. So these are realities of life. And here, again, the sympathy or empathy is an issue for the mediator. The mediator cannot say, get out of the marriage. The mediator cannot say, what then if he has hit you? He is such a rich man, good man. He gives you all the luxuries of life. Sympathy is identifying oneself with the party. Empathy is understanding the problem of the party. So the mediator will not say, oh, so sad, he beat you. Then I'm going to see what happens. He can only say, okay, I understand. It must have hurt you badly, emotionally and physically. So he earns the, what should I say, understanding of the party, that the mediator has understood her pain and suffering. Most difficult thing in a family dispute, therefore, is to understand what lies inside. And what comes in the way is the fact that the parties themselves do not know what is hurting. In a commercial dispute, the party knows the loss of profit. You see a lot of market etc., etc. But in a family dispute, why this fight? They themselves do not know. So what the mediator does is to take them through a process which we call catharsis. Let them speak. You know, as a judge, we would stop a lawyer after 5 minutes. This is all. I have understood what you want to say. But the mediator will not say it. Mediator will say, please speak more. And we are made to put questions which induce them to speak more and speak, speak, and speak. So what happens when one speaks? One is healed internally. When one speaks before a mediator in a formal surrounding, the other person is hearing. And maybe for the first time, the person feels somebody is hearing me. I'm able to convey my feelings to the other person. And it is not only the husband and wife. It's the same is the situation with the mother-in-law, the father-in-law, who feel that they have never been heard. Their problem is somewhere, and he or she may not himself know where the problem is. I'm giving a very small example of this nurse. You know, nurses have shifting duties, sometimes morning, sometimes evening, sometimes night. The family was happy to marry the son with a nurse because the family thought she will be an additional earning member, an educated person. But after some time, the mother-in-law started having problem with the daughter-in-law. She has no time for me. She has no time for the family. She sleeps through the day. She does not come out to meet the relatives. And then the child comes, then the problems increase more. She is not the only one to have a child. We also had children. Doesn't mean all the time you are busy with the child. So what is the issue here? So as it goes on and on and on, she agrees, you know, when the things come out, well, she is a nurse. She may have a night duty, yes, the mother-in-law agrees. Mother-in-law agrees when she has a night duty, she has to sleep in the day, yes, mother-in-law agrees. If she is sleeping, taking rest because she has to do a duty in the night, mother-in-law agrees, fine. So if she is to sleep, she can't come to the kitchen to cook or meet the guests who have come at that time, mother-in-law agrees. So what is the issue? The issue is, mother-in-law says, when she returns in the night after an evening duty, some gentleman or the other from the hospital comes to drop her home. So what is the issue? She doesn't want to travel alone in the night. This is not a good city for women to travel alone in the night. So some colleague comes to drop her. Now the mother-in-law also has to say, yes, this is true. How can she come back home alone? Then what is the issue? The issue is, what will the neighbors think? Now, this is something the mother-in-law has said only after 2 hours of catharsis. What will the neighbors think? The mother-in-law coming back at 11 o'clock today with Mr. X and tomorrow with Mr. Y. See, this is the core of the dispute which mother-in-law herself does not know. So now the cause is no, you can apply the medicine. So what can be the relief? What can be the solution? Will any of the participants answer? What can be the solution? Mother-in-law say, let her give up the job. I don't need her money. How many of you agree with the mother-in-law? Will anyone reply? Any of the students? Dr. Verma, will you unmute yourself?
Yeah, yes, ma'am.
Yes. Yes, what do you think?
I
You
have
wanted to say
received,
something. I found
yeah,
your
no
lips
negative
moving,
one.
so I thought you have something to add.
I was, no, ma'am.
We do have some participants, ma'am, trying to answer in the chat box. So one of the participants is saying that they don't agree with mother-in-law to give up the job. Yeah, that's what we have received. We'll wait for other participants to also post their answers. Participants, please keep posting your answers in the chat box as asked by Justice Goel. We have received another answer that they don't agree. So there are participants who are saying that they don't agree with mother-in-law.
So what is the solution? Do they offer any solution to this issue?
I would request the participants to please come up with a possible solution which you think is right for this particular case so that we can discuss it further. Whatever you think. Yes, ma'am, we have received one answer saying that giving up job is not an amicable solution. Addressing interest of both parties must be done. Arrange safe transport for the daughter-in-law. There is another participant, she's mentioning that maybe the daughter-in-law can carpool with a female colleague. Then we have another contribution saying that they should opt a cab service to drop her at night. So broadly, if we say they are thinking that giving up job may not be the correct option, there are possible ways by which she can maybe travel and avoid giving up her job.
You see, this nurse, this lady has already found a safe way of traveling to be escorted by a colleague. So the real issue is in the mind of the mother-in-law. You see, it's not the traveling issue. The issue is in the mind of the mother-in-law. Kuch to log kahenge. The mother-in-law must overcome this. So the mediator has to put it in the mother-in-law's mind. Kuch to log kahenge. Ignore what people say. Look at the reality. You know that your daughter-in-law is a devoted wife, a dedicated mother, a very, very good worker. She looks after her career, which is good. She is not in the wrong. So to overcome this prejudice of what people will say, you see, the people are nobodies. They don't care for the family. So the real issue is in the mind of the mother-in-law. And so what is required is counseling to the mother-in-law. And mother-in-law also appears to be a rational person. So I think one of the solutions is to counsel the mother-in-law and tell her that she must ignore the neighbors, or the neighbors will understand sooner or later that this is how the life goes in this house. Of course, that reduces the problem if she has some other arrangement. Why not send the son to bring her back in the night? Why not the husband take the responsibility of taking the wife back home from work? So these are various solutions. One, we have the solution, as Justice Sarin said, the mediator cannot say, forget, give her a bus, give her a car. The mediator can only suggest, can the family think of some other solution? The mediator can specially counsel the mother-in-law or the son, the husband, to bring about this kind of faith in the family that they are not concerned with what the neighbors might think, which is not true at all. So this kind of confusion in the mind, The mediator sometimes has to become a psychologist. Even in that movie, neither of them really knew why the dispute has taken place. The dispute lay not in the situation, but in the mind of the people.
Yes, ma'am. Just to let you know, in the chat box, few more comments in this regard we have received. So somebody has said that, Dhanashree has said that it is a prestige issue for mother-in-law. She ought to be convinced that the difficult job of a nurse has greater social prestige than what the regressive views the neighbors hold. Also attached to it, there is a question which you might cover when you are addressing this issue, that is mediation sufficient or an appropriate forum for overcoming these social prejudices?
No, I couldn't get the last question. If mediation sufficient or?
Is mediation sufficient or an appropriate forum for overcoming social prejudices? That is related to the discussion which we are having.
Okay, all these questions can be answered, but then I do not know the time frame. And this is a good question. I think if I send this question to Justice Sarin, whether it is the mediation or some other forum where this, you see, this social prejudices will have to be addressed at every forum. In every forum, these social prejudices will have to be addressed, and why not in mediation also?
We have sufficient time,
We are
ma'am.
not to resolve, we are not to cure the society. We have one small problem at hand, and we have to see how this problem can be resolved. It is, how this family has to go on. Okay, divorce could also be a solution.
May I
Yes.
just to supplement what Justice Goel has said? You see, any judgment by a judge also, where such issues are raised, covers the societal aspects when involved. And every day we do it. So the forums are unlimited. Whichever forum is concerned with it, will deal with it. For instance, if you are in mediation, you will of course try to explain to him, look, such things, if you carry a belief that someone else has dropped, it is archaic. Forget it. You are not in the 18th century. In 20th century, it is nothing wrong of a colleague dropping your daughter-in-law. So therefore, you will, as a mediator also, you will bring in a social reform of this nature. Similarly, you take it if in a matrimonial matter, somebody raises this issue that, look, earlier, if you go back to the 19th century, the English law was, if at any time a young couple was found going into a hotel, the presumption was it was adultery committed. Today, I think there is a question mark. Those two could be there if they are involved in some official or other work, and spending time and have booked a room. The English judges said, when two young people are together in a room, they can't be imagined to be reciting biblical verses. I think we have traveled a long way from that. Now, two young people can be together for writing something. So these, every judge with the advancement in society, you do that. There are forums which take care of it. And I think Dr. Qureshi may like to speak on this better.
Counting money private, for example, in the recent case, the newspaper reported two of them went into a room in a hotel, and it was believed by the prosecution that the two were there counting money in privacy. So even without the biblical verses, there could be many other things that they might do in privacy.
We are in the advent of where it is being debated in the forum Today, the case is going on whether gay marriages ought to be legalized or not. So we have traveled a long way, and that is a part of sociological growth.
Is Dr. Qureshi?
Yes. Thank you for this opening. Justice Sarin, you took me back about 35 years when I had attended a course in Boston in a totally unrelated kind of institution, Management Sciences for Health. And it was a course on international health management. But the best course I have ever attended. And one of one of the lessons we learned was exactly what you were saying about dispute resolution and the ingenuity, which is another alternative expression for out-of-the-box thinking. So, they taught us management concepts through games. And I think that is something which I was trying to remember whether I can recollect totally and introduce it in our IILM. Now, this game was like a tambola. Tambola, there are two teams. They're given some chits and they are asked to bid against each other. And then there is a moderator who says, look, I am a moderator available to you if you want me. Otherwise, you're free to kill each other. So initially very confident, no, we will destroy the other guy. So we bid in such a way that we are destroying the other, but in the process, we are also harming ourselves. So the moderator comes to us after some time and he said, do you still want my intervention? We are still confident. No, we'll handle it. The game goes on. Then he comes after 10 minutes. Do you still want me? Now with lesser confidence, no, we will manage. But at the same time, in the heart of heart, we know we are also losing. Finally, the third attempt, we said, all right, please intervene, please moderate. And then he helped both parties to bid against each other in such a way that they're both winning. And we both end up winning and the win-win situation. It was a very, very powerful game, which I still remember after so many years. Now, Justice Sarin started with a very shocking declaration how we are almost at the bottom in dispute resolution mechanism, which is something we should be aware of and we should be embarrassed about. And just as Prime Minister took it upon himself to improve the ease of business, and within 1 year we improved 30 positions. I hope someday somebody takes it up, the Chief Justice or the Prime Minister, and we do something about it. Now, the camel story also, this was very, very interesting. That was out of the box. I have in my family, my brother, who always plays that. If the two parties have some dispute, he will offer his money. That is to resolve the issue. No, he doesn't get his. He doesn't get his camel back, but he doesn't even want it. But he is happy to play that role. There's little intervention from the elder that works very well.
Okay.
One thing which, once professor gets a time, he doesn't stop. Now, Dadi Ma's quotation, which also comes to my mind, Hisab Jojo, Bakshish Sausa. Now, even among siblings, even between parents and children, when we are accounting for something given to us, it has to be every penny accounted for honestly. But whereas the elder brother, as you refer to, that elder brother, when you appeal to his ego, okay, look, you're the elder, like a father figure, you be charitable, he will be very happy to give away everything. But at the same time, hisab has to be barabar. Bakshish can be something which is what should be in the family dispute. Madam, they mentioned Abhiman. I have seen that film, madam, and really, really very powerful film. And another film which comes to my mind, which also is doing dispute resolution all the time, is Bawarchi. When Rajesh Khanna, it's about a family. There are 3-4 brothers always fighting. All kind of bitterness and bickering is happening. But all that this guy does, he goes to one brother. Do you know your younger brother was praising you? So the elder one sits up, Acha, really? What did he say? And he tells a lie. And suddenly the elder brother feels good about his younger. And it goes on, and he brought the entire family together only by reporting the positive thing, even concocted at times or exaggerated. So, that kind of a role. And the ego, of course, the core of all these disputes, whether a commercial or family disputes, it's ego and the prestige issue, which, madam, you mentioned again. Now, finally, the one thought which comes to our vice chancellor is a psychologist, that psychology and the dispute resolution mechanism in the legal context, they have to be studied together. Maybe we can have a joint class of psychology and law dealing with the same issue, because half the lecture of Justice Goel and also Justice Sarin was about psychology, dealing with these issues, dealing with the ego. And if we are conscious of
Can I go to the last part of this family dispute part? Just a
Yes.
small part, because this is also important. So I don't want to give up. This discussion is also important, but we have a little time constraint. So can I finish my speech and then we can...
Please tell madam the time constraint. We are on till 12:30.
Sir, we have ample time. Yes, sir. We can go on till 1. So we have.
Oh, then it is fine. Dr. Qureshi, please
Yes,
go
sir.
on. Please,
Yes.
please have your say.
Yeah.
No, I'm done. I made my last point that a possible psychology and law class together on this issue may be something we can attempt.
Yes, sir.
So
Well, like,
we can have
ma'am,
an official screening of Bawarchi also, along with Abhiman, for whoever is trying to learn the techniques of mediation.
yeah, ma'am,
Now,
and
one-
sir, with your permission, I would like to add, which Dr. Qureshi said, and Justice Sarin also mentioned emotive in her address so many times. Until unless you are not able to understand the emotion of the people, we are not able to give any kind of judgment. So rightly, the integration of law and psychology are already we have introduced here. This kind of integration is very important. Even, ma'am, apart from mediation, any other issues related to individual behavior, even in crime, we need to understand the psychology and unconscious mind of a person who is doing the crime or who is doing the irrational behavior or something. So as suggested by Qureshi sir, always we will try to integrate psychology. We have a full-fledged department with law department to use these kind of concepts.
Okay, now I will come to the issue of children. Issue of children. If I break family, Family, and if I coin this definition of family, father and mother, I love you. This is family, Family. This is the family. The child is the worst affected person in a matrimonial disputes. When the parents fight, who will assess what the child is undergoing? Just a few days back, I was listening to a lecture of a psychologist who was talking about a child who is a victim of parenting alienation. He said parenting alienation. When one parent is alienated, it is so common when the child is in the custody of one parent, that parent keeps telling the child, I am the right parent. The other person is not your right parent. And sometimes they say bad things about the other parent. He is bad, or he is a cheat. He doesn't care for you. And similarly, if the mother is the non-custodian parent, then the mother is also similarly attacked. And what happens to the child's mental development is horrible. So this child, has to be taken care of. And in our legal system, when the parents fight, the child goes totally unrepresented. Child doesn't have a lawyer to represent. And very often the child's thing is considered only as a matter of custody dispute. But there is more to the welfare of child. Now, children are bridges. Every day there are bridges in our families. Every day the mother and father fight. They don't separate. If it had been a business dispute, the partners would separate for this kind of fight. But the child is there. The child binds the parents. Every day they are bridges. And even when the parents fight, the children can be used as bridges. In fact, if both are conscious of the harm they are doing by not living together or breaking up the marriage, well, I think another aspect to reconciliation will come in. You see, this is again a very serious issue. The right of an individual, the right of a family, the rights of a society, how much the woman can be made to suffer for the sake of the family, how much the man can sacrifice for the sake of the family, is his own happiness not important, and eventually what is happiness after all? All these are again very complex issues. But let us for the time being concentrate on the role of a child as a bridge between the father and the mother, and how the mediator can use this role of the child in bringing about reconciliation in a family. As I said, it's not a marriage between one man and a woman, it's a marriage between two clans, in fact. And when reconciliation takes place, the two clans come together. Now, I'll give you this one personal experience when, as a sitting judge, I experienced this. When I asked the man who came with the suit for divorce that on so and so date, you and your wife will come in my chamber for an effort for reconciliation. That man in anger forgot that I was a judge. He started scolding me right there inside the court. Do you think I'm mad? I'll take this woman back home. She did this, she did that. I said, I'm sorry, this is the duty cast upon me by law. You may not take her home, but I have to do my duty. So on the appointed day, the husband and wife come and I talk how they separated. Lot of things, kind of catharsis takes place. And I said, where is the child? So I give them a date, bring the child. The next day, the child doesn't come. What happened to the child? Child has an exam. How big is the child? Child is 6 years old. He has an exam. Exam is so important, meaning thereby the mother is protecting the child from the father. He need not see the father. I insisted on the child coming. So the next day the child comes. Now the child has never seen the father. He was separated when he was an infant. And the father all this time yearning for the child. You see, this feeling we must realize is not only in women. We always say the mother's yearning, but we ignore that even the fathers have the same yearning. And this father has brought a few gifts in his hands for the child. And the child who has never seen the father is a stranger for him, doesn't want to accept the gifts. And eventually the mother coaxes him, no, you can take the gifts. He takes the gifts and the father pats him on the head. And now the entire emotion, the suppressed emotion comes to the fore. And the father breaks down in loud sobs. I've hardly ever seen a man crying that way. He's sobbing and sobbing, inconsolable. Think what the wife must have been doing. What is the wife doing, seeing the husband crying after meeting the child? And able to see the child after 6 years. His own child, his own blood. What is the wife doing? Dr. Qureshi, do you have any imagination what the wife might be doing then?
In fact, you made me think. I'm thinking that, but I got the feeling that the wife was very unfair and was cruel by keeping the child away from the father. So probably she was the one who needed psychological treatment.
What is the wife doing when the husband is crying before the judge? And the child is perplexed. What is the reaction of the wife?
Well, there could be two. One, she'll feel on top of the world, having made the husband go so low as to cry like a child. The other, she also should become emotional, and she should also shed her ego.
Absolutely, absolutely. Will the children, my audience, student audience react? What the wife might be doing at that time?
I request the participants to please post your comments in the chat box. I will be reading it out for ma'am. One participant has mentioned that she must also be emotional.
Well, you know what in reality happened? She is consoling the husband. She is emotional, but then she is consoling the husband, please. You see, what does it show? It shows she is feeling the same pain. She is sharing the same pain. She knows what the husband has undergone these 6 years without seeing the child. He is not simply father, he is a mother. This is what we must all understand. Men don't cry, doesn't mean they don't get sad. Now the psychologists are saying men should be allowed to cry. So the man, just as a mother would have suffered, yearning for the child, the father has been yearning for the child. And now the mother, the wife is consoling the husband, taking his head in her arms. Now what happens, in this process, the ice is broken. The hard feelings between the husband and wife gone. They both understand the pain of each other. And of course, the catharsis, the parties knowing, understanding each other, why, what happened, when happened, why it should not have happened. So there was a reconciliation between this man and a wife. The man who said, "Am I mad?" is scolding the judge for inviting him for a reconciliation session. He takes the wife back. I don't finish the case, keep giving him dates. And one day he says, we have another dispute to resolve. And so, I'm slightly nervous in my mind. What new problem has arisen between them? So they come in my chamber and I ask, what is the new issue? They say there is one issue which is left. Who has won? Because both are claiming to have won the dispute. So I told them, both of you have won, as Buddha said. The real victory is one in which both are victorious. So this is a war, both of you have won. So there are many other situations in which I have been able to use children to bring the husband and wife together. In one, the children fell sick and the father said, give me the custody, the wife is not able to manage. Eventually, I sent them to a nursing home with a direction that the father and mother both will be there in the nursing home. So both, though fighting a divorce litigation, are in the nursing home looking after the children. And again, both sharing the pain and agony, the worry, and that is what brought them together. So children are every day's bridge. And of course, there are, apart from catharsis and finding the real cause of disputes, there are other solutions, which we say behavior modification. Maybe one party has some behavioral dispute, not understanding the other party, how one behavior is affecting the other behavior. So they are, of course, in the area of a real psychologist. And here I advise the mediator should have the benefit of a psychologist who can say how behavior can be modified, because behaviors become nature and it's very difficult to change somebody's behavior. But behavior modification is another great area in which a family mediator can work. Now, can I now invite the
Dr.
students?
Goel, we had counselors for this. Very often in mediation process, we had used counselors.
Yeah, they are all psychologists. They are all psychologists.
Just I want to add two things. You know, Dr. Goel has rightly given you examples in the process of mediation where, you know, child is used for is a bonding factor. That is true. I mean, if something can bring the two together, make them forget little differences or major differences, it is the bonding of a child. But I remember one case which I had handled way back as a lawyer, where, you know, there was hardcore selfishness to an extreme. You know, there was this German businessman in India. He had his wife who was way back in Germany and had children. He had fallen in love with a girl, with a woman here, and they both got married. And this woman had put a condition which he enforced ruggedly, saying he would not meet his children. So I told, they came once or twice. She said, I want a divorce from him. So I asked the man, I said, what is the cause? Why did you marry her? Why does she want a divorce? He said, look, she is putting a condition that I go twice in a year to Germany. And when I am going there, she says, you are not to meet your children. So I told her, the lady, that this is inhuman. I mean, how can you put a condition of this nature that he would not meet his own flesh and blood? So she says, nothing doing. He professed unlimited love for me. This fellow can go and love somebody else like this. He left them and is married me. I don't trust him. But if you didn't trust him, why did you marry him? So, and can you imagine the wrath of a woman? Sir, one day he came crying. They had a fight, and this woman, he had a toenail surgery, you know, ingrowing toe. And this woman stamped on his toe because she heard him talk to his first wife and the child. So at times now, a situation like this can be the other cause. And then there are people, ultimately, I told this client of mine, I said, you are better rid of her. And it happened that way, made a generous offer of settlement, matrimonial alimony given, and they got a divorce. Similarly, in another case, I recall the example that she gave in court, Manju Goel, we are not naming the judge concerned. What had happened this was the High Court. So the judge was quite perplexed. Two persons' case was lifted for reconciliation. You know, he found the lady very presentable, good looking, and he asked her, this why I'm mentioning, you know, you should not do it in open court. You ought to do it in chambers. You ought to spend time in mediation. You ought to spend time to understand their dispute, which is at the core of mediation. our colleague made the mistake of in open court asking her, अरे क्या हो गया, तुझे क्या तकलीफ है? अच्छी भली तो तेरी ये लुगाई है. She was a good looking woman. He said, अच्छी भली तो तेरी लुगाई है. And you know, the client in his simplicity said, तुझे इतनी भाई तो तू ले जा जज साहब, मुझे तो नहीं चाहिए. Now, you know, so what does this teach us? That in matrimonial sensitive matters, you cannot take them in presence of others. You must meet them separately, try to understand their problem, and then, as we said, come to the core issue, then find solutions. And, you know, talking of Dr. Qureshi, we gave an example of camel heading to the kitty and expanding the horizon. You know, the civil procedure code permits you that if you have a dispute A, while settling dispute A, you can bring in other concerns, other disputes that are there within that settlement. So a settlement here can include other disputes between the parties. So that's why another example which is very often quoted in the mediation is the oranges, the juice and the peel and the pulp example. You know, one man, the contract was to get the juice, and the other fellow, they said, all right, you take the juice, the pulp was being retained by him. They said, all right, give him the pulp and the peels, he'll make marmalade out of it. So that's why this is something external. From within it, you found a solution. Yes, Manjuji.
No, the students have one question I noticed, the other I could not. One question is whether a person who is not trained in law can be trained in mediation. I will say yes, he can be trained in mediation. Particularly in areas where law is just a side business, you can be a mediator. For example, between the master and servant, for example, say the management and workman, if you are in the same department, same company, you know what the management wants, you know what the workman wants, and you can perhaps work as a mediator. You know, the first mediation case, if Justice Sarin remembers, I and he were playing the role of two parties where Sriram Pachu was acting as a mediator. This is a role play method of teaching. You know, this was a role play method of teaching. We were in the National Judicial Academy and we were demonstrating mediation, in which I played the role of a workman and Mr. Sarin, Justice Sarin, was playing the role of a management, and just Mr. Sriram Pachu was demonstrating the role of a mediator. You remember, Justice Sarin? Very long time back. So what had happened in that case, the workman had been dismissed by the management and he had sued the workman for reinstatement with all back wages, etc., etc. And we negotiated through the mediator, do this, do this, do this, and it turned out as the facts. The workman, meanwhile, while being out of service, he had educated himself, he had earned certain degrees, and he was not qualified for a better job. And in fact, he already had a job offer from another organization. So as a mediation settlement, the same management offered this workman another job at a higher salary, at a more senior position. So this is, you know, something which only mediator can do, this magic. The court cannot do this magic. So the workman may have, given up some part of his claim for back wages and other things, other facilities, but accepted a new position at a higher salary in the same management, because now he is more qualified and the management needs a person of his training. So
Yes,
these
go
are
ahead.
out-of-box solutions.
May I at this stage add one thing? To answer this question, whether a non-lawyer can be a mediator, my answer is more emphatic. Yes, as a matter of fact, some of the persons who are non-lawyers are far effective mediators. If you remember Manjuji Banke Bihari, he is a very great trained instructor and a mediator, and the emphasis is on communication skills. A person who can communicate effectively can be a very excellent mediator. Now, Banke Bihari excels in this. How to have postures, for instance, in a mediation session, manner in which you are going to sit down, cross-legged, not to yawn, how you make the person feel eye-to-eye contact throughout the proceedings. So, let me put it this way. Dr. Qureshi, as a seasoned orator, would know that anyone who is indulging in public speaking, when you are having an eye contact, you can make out this is the time for rapt attention. Rapt attention we can have of the audience for 5 minutes, 10 minutes. And after that, we know it is dwindling. So a good speaker turns around to something else to get that back. Similarly, a mediator who's excelling in communication skills keeps the thing on and does not let it go out of his control. So my answer is more emphatic. Definitely yes. A non-lawyer can turn out to be a good mediator. And you see, you are not circumscribed by constraints of law. Whatever settlement, if it is against law, when it goes to the court for implementation, that will be corrected. It will be brought within the four corners of law. It doesn't matter. Yes.
Okay, there is one question about power imbalance. Okay, it's a very, very important question. And I'm surprised at the maturity of the person who has put this question. How do you handle power imbalance? So some people think that if there is severe power imbalance, there can be no mediation between them. My answer is different. My answer is, if there is a power imbalance, the mediator must empower the weaker person as far as possible. If it is not at all possible, then law may be the better course. But you can jolly well empower. For example, I had a girl in a matrimonial dispute, and when I said, if you divorce, you can get maintenance, you can get this, you can get that. And, she was so weak that she had just surrendered to fate that she will be thrown out of the house and she will be ruined for her life. But in a private session, when I told her that, you cannot be thrown out of the house because the man has such obligations. So this is how I could empower that girl. Or I could tell her about, which is not barred, I could tell her about the NGOs who are working for the benefit of such kind of abandoned women who can take care of the women who are not educated, unemployed, how there are organizations, opportunities for them. So this is the way to add power to the person who is lacking in power. The balance has to be there because it is, after all, an assisted negotiation. As I say, mediation is a process of assisted negotiation. So negotiation can be within equals, between equals. So please empower the weaker person so that he also has some footing. Okay, bring her examples where poorer women have done good in life. So let her have a first-hand experience with an NGO who can take care, the shelter homes, the short stay homes. Give her some strength to fight on.
Yes, ma'am. Ma'am, we have few students lined up who want to ask some questions. So I would request Ekantik. Ekantik, can you ask your question? Yes. And we have Ekantik here.
Yes, ma'am. During as we know that the mediation plays a very important role in the family issues. So, during the COVID time, how did it affect the mediation process, and was it able to be conducted online?
Online. Well, certainly the mediation process can be conducted online, but I think it is better done in physical presence of each other. It can certainly be done online, but physical presence is something very different from this online business.
Yes, ma'am. And to add to his question, what he's trying to ask is that during COVID times, it was a little tough for everybody to have offline processes. So, was there any challenge which was faced during mediation process while this COVID time?
I did have
Let me
some,
put it
I
this
did
way.
do
Mediation would have suffered as did all other things during
all
COVID
other
time.
things, yes.
I mean,
I
there's
think
no
that's the
difference.
only answer.
Rather, mediation would have suffered a step further, because here you need physical presence to arrive at a settlement in some ways.
Right, sir. Now we have another participant asking a question. Anvesh, Anvesh, you can ask your question. Yes.
Ma'am, good afternoon, sir. Good afternoon, ma'am.
Yes.
So, ma'am, in my limited experience of the
I think you will have to repeat because part of your speech was incoherent. Please please speak again.
Hello, ma'am. I said good afternoon to sir and ma'am.
Yes.
Ma'am, I'm a practicing lawyer and I'm pursuing my LLM from IILM University at the moment. And in my limited experience of practice, I have seen more success in mediation in Supreme Court than the high courts and the lower courts. In that order, could it be that the finality factor psychology at play? So, I mean, there is let me just rephrase my question probably in this way that could it that the litigants feel less motivated to settle in lower courts, but may change their stance when they realize that this is the final forum?
I will first of all dispute your perception that there are more chances of mediation success in the Supreme Court, because your observation is not based on any empirical data. Please look up the data of success in mediation in the various mediation centers in the district courts and the High Court.
Ma'am, I'm only limiting physical experience. Sorry to interrupt. I'm only limiting my aspect to the psychological aspects of the party and dispute.
Whatever, please don't have this notion that mediation is more successful in Supreme Court than in earlier stages. Secondly, as Justice Sarin has coined this word, litigation fatigue.
I was about to tell him that.
So I have learned it only from Justice Sarin that there is something called litigation fatigue, when there is one final stage when man says, okay, let it be done. So that may be that fatigue which forces them to say yes or no to a suggested solution.
You see, when you reach the Supreme Court, you have had rounds of litigation. Financially, you are exhausted. Mentally, you are exhausted. And then it is the highest court, and they are referring you for mediation. So there is a psychological subconscious pressure on you to settle. In that sense, it is not purely voluntary. But notwithstanding that, I think the major cause for settlement there is litigation fatigue.
Yes, sir.
Because parties have really worn out by that time, and they realize nothing much is going to come out of it. Let's settle. And if there is an implication, let me tell you how it happens. The court, and I plead guilty for doing it because you are violating the basic ethos of arbitration. What used to happen even at the mediation center, when Delhi High Court, the 3 4 judges we were in charge, we used to take a round. And at that time, now normally mediation has to be without any pressure or sense. But what would happen is we would walk across and ask, how is everything going on? The two lawyers are negotiating, parties are there. And we say, ask the mediator, how is it going? He said, sir, was try kar raha hu, inko to, what is the dispute? He would say, broadly, this is there. I'll say, don't worry, this lawyer is a very reasonable person. And I think they will both work out. You make some more effort. Now, when the two lawyers would hear a High Court judge telling them that this is their perception of being a more conciliatory, acceptable person, he would add to it and push his client also a little. And we would have greater results in mediation. So from the Supreme Court, a nudge comes. You would have this mediation, settle it. And we are adjourning it for 3 weeks. So there is that impetus to settle also. And then litigation fatigue as far as Supreme Court goes. Yes.
Thank you so much, sir. I also would like to address one more thing.
We have answered your question.
Yes, sir, yes, sir, I followed. Ma'am, I would also like to address one more question with respect to the children's development you just mentioned while I was listening to your point on the how children are affected so badly when there is a dispute in the family. Now, I have came across with one of the matters while in the practice where the girl was widow and she had two children, and they both one was the elder daughter, one was the infant, and the grandparents were not willing to. This widow girl was pretty young, and the children's the grandparents did not want to share their part of lineage, their family lineage to go with their mother if she chooses to remarry. Now this became a big dispute, and how children were misguided by the grandparents that your mother was the wrong person and your mother is the wrong person to go forward with. So my question is like how to deal with this situation, ma'am.
It's a very unfortunate situation in which the children are in custody of people who do not have, cannot think straight. You see, as the children are in the custody of the grandparents, if I have got you correct, then it is the grandparents who bring up the child. We are all influenced by the thinking of our own parents. Yes, you see, if my parents have a particular thinking, this is good and this is not good, women should dress like this, men should behave like this, it is good for men to eat, drink and make merry, it is also good for women to do so, or for women, I mean, all these notions of values, they all come to us from our own parents. So it may come to them if they are in the custody of grandparents. Their value system of grandparents will be transferred to the parents. Okay. Now, if law is concerned, if the mother has a better right of custody than the grandparents, unless she is disqualified for some reason. In that situation, mother should get the custody. And even if the grandparents are getting the custody, the mother should have the visiting right. And in that case, if the mother visits the children who are still in the custody of grandparents, there will be communication between the mother and the child. So what is important is the development of bond between the mother and the child. Law can take a part of it. You see, you can take the horse to water. The drinking has to be done by the horse. So if I've got you correct, it is the grandparents who are standing in the way of understanding developing between the mother and the children. Law can come only to the extent of getting the mother the custody of the children, or at least the right of visit. And now we
Yes,
have the new concept of shared parenting. The Law
ma'am.
Commission is recommending shared parenting, that even when the parents are not together, the parenting has to be shared.
Right, ma'am.
Because the child, has to grow up with that feeling of sense of security that I have a father, I have a mother, I have a loving mother, I have a loving father. Otherwise, the child's personality will not be balanced. And I have tried it with mothers, telling them, look, for the benefit of your child, you have to allow access to the father. Access to the father is not for the father's benefit. If the
Right,
mother or father is being allowed access to the child, it is for the child's benefit. It is for the court to push it into the brain of the custodial parent that your task will be complete only when you fully allow the child's personality to grow in a balanced and healthy way. And for that, it is necessary that the other parent has access to the child.
Very well, ma'am.
Coming to your example of the grandparents, I think, as Justice Goel said, law can take you up to a certain limit. The real solution comes with the change in attitude flowing from societal norms in the perspective of the grandparents. You see, tell me, the grandparents, there are people like grandparents who in similar situations treat the daughter-in-law and daughter as the same. If you
Yes,
do
sir.
not distinguish between your daughter-in-law and you treat her like a daughter, then you would be looking after her. And as a matter of fact, you have come across many movies also where they picturize that the daughter-in-law who was widowed at a young age, the in-laws are encouraging her to get settled.
Very well, sir. So, but I have an situation, sir.
So, there's a perceptual change required. Law protects you, all right. Law will get her, and the whole thing will depend upon what are the qualifications of the daughter-in-law. Is she able to survive economically herself? If she is totally dependent on the in-laws, then it's a different matter.
Certainly, sir. Certainly.
Then those
I
compulsions come in.
Yes, sir.
Thank you. We also have another participant with a question. Can we have Dhanashree? Dhanashree, you may ask your question. Yes, Dhanashree.
Yes, good afternoon all. My question is, can mediator be a omnipartial rather than neutral in solving the dispute resolution?
Can he be?
Omnipartial rather than neutral. When there is a mediation or resolution of disputes, can he be a omnipartial, like he can be on both sides, or he should be a neutral only?
No, he has to be neutral. Otherwise, how will the parties have faith? You see, the mediators first, Justice Sarin talked about the opening statement. Now, opening statement is a long statement which the mediator makes in order to lay down the rules to be followed by the parties during mediation. But the most important part of the mediation statement, the opening statement, is to assure the parties that the mediator is going to be entirely neutral. And that is how the mediator should show his empathy, not his sympathy. The moment the mediator shows sympathy, it shows the mediator has gone with one party. Or mediator sympathy, one party will mean the other party is at a disadvantage. So the mediators are advised to say, if some party has narrated a story of agony, the mediator will say, oh, I understand you have undergone a lot of pain. But he is not allowed to say, oh, you have undergone great pain. I will see that the other man pays for it.
Or the other man caused it.
or
Yes,
the
yes.
or so and so. So the mediator will understand the agony and will say, I have understood your agony, but not more than that. So not only he should be neutral in the beginning, in the in the initial stage, but throughout the stage he has to maintain his neutrality. At no point of time he can show his inclination towards one party or the other. And if there is some connection between the mediator and one of the parties, first of all, the mediator's ethics will say, you don't take this case. Like a judge will not take a case in which one of the party has some kind of relation with the judge, some acquaintance, some friendship.
Yes.
Similarly, a mediator should not become a mediator in which he may have a distinct kind of an interest in one of the parties. And throughout the mediation process, he must not only remain neutral, he must all the time demonstrate that he is neutral. He should not only be neutral, he should show that he has been neutral.
Yes, yes, ma'am. Thank you so much, ma'am.
Thank you, ma'am. We have a couple of more questions in the chat box. Should I read it out, ma'am?
Yes,
For
why
us
not?
to-
Why not?
Yes, yes, ma'am. So we have one question. It is how to deal with disputants who are unwilling to participate in mediation proceedings despite of referrals made by court.
Yes, Justice Sarin, will you answer this?
Come again. How are?
If the parties are unwilling to even take part in the mediation process,
Despite of reference made by court.
Despite the order passed by the court.
Yes, sir.
You see, the mediator is duty bound at that point of time to at least make a beginning, attempt a beginning, and ask them, tell me what is the problem. And listen to each side's version. And then try to break the ice. So if he is a successful mediator, having all the qualities of it, the chances are that parties may turn around and say, all right, we will make an attempt at it. In my experience, at least in 80% of the cases, they don't lose anything by saying, all right, we are making an attempt. And secondly, what happens is, this does not cause any prejudice during the proceedings. Now, in mediation, two things are very important. Parties are free to make any offer or adjustment, or to say, I am willing to give this or not to give this, or the other party. That party can't go to the court and say, this man was willing to settle for so much. He was offering me maintenance of so much. All that is disregarded. It cannot be taken in evidence to preserve the confidentiality and sanctity. Once this is brought home to the parties, they feel open and are willing to discuss. And that is why in family businesses, what you call the number two accounting also, people share before the parties what they are not willing to admit otherwise. In writing in a suit, they will admit that yes, these are the entries, only this much is due. So there is greater scope of vetting it, but all right, if parties do not want to settle, there is no way they want to settle, you can only make an attempt. And then as Manjuji said a little while ago, you can take the horse to the water, the drinking part has to be by him only. Make an earnest attempt, 9 or 8 out of 10 you will succeed. But if they're not willing, let them suffer the litigation fatigue. What is the alternative? They go back to the court and there will be no settlement or no decision in sight for 5 years. The moment this realization comes, they come back to mediation. We have cases where people initially say no. When they fight for 5 years, after that they come back. I remember a very interesting case. I will not name the industrial group of Delhi itself. This litigation was going on before me, and they had multifarious litigations. They had Company Act cases, they had cases under the patents matters, they had cases for possession, they had cases for assets being taken away, large two factions shareholding disputes between the a major group. And so litigation had been going on for quite some time, 5 years had gone back. And though one day I said, don't you think it's time for you to take a stab for an overall settlement and see if it is workable? So that's how this phrase came to my mind, and this is where I picked it up from. So I mean no insult to any community or religion. One of them was a lady. I said, has not litigation fatigue set in? She says, sir, my lord, you don't know the capacity of 6. They have endless energy. They will continue for more time. I said, hold on. And 2 years later, they came back. So litigation fatigue will set in and then they will settle. Sometime or the other, the utility of mediation will come home to the parties, either by litigation fatigue or otherwise, or they find litigation expensive. I mean, let's not forget, today, litigation is not easy. If you are hiring senior counsels, on an average, at times, the hearing costs you $500,000 to $1 million of rupees, 1 day of hearing. And I am being conservative. You agree with me, Manju?
Sure.
Yes, sir. Sir, I have one more question. The question is, what is potential of pre-litigation mediation in matrimonial disputes?
I mean, there should be a rule that you can't come to the court before you have been to the mediator. Pre-litigation is the best time. You see, you know how the matrimonial mediation starts. It starts with a complaint to the police. And if it goes to the police, gone forever. You know, goes to the police means the husband is rushing to the court seeking anticipatory bail. His parents are seeking anticipatory bail. Somebody may have been arrested. So all these things, the whole thing is complicated beyond imagination. So please come to the mediation table first. And before the lawyer tells you what story to exaggerate, what story to cook, what is, forget the difference between truth and fiction, and you mix up and make a pleading. That is why I always advise judges not to read the pleadings when you are hearing the parties in the reconciliation session. Don't read the pleadings because the pleadings are half true and half false.
Thank you. Yes, thank you so much, ma'am. Thank you so much, sir, for addressing all our concerns and queries.
There is one more question which I saw. Are the mediators allowed to show emotion?
Yes.
Am I correct?
Yeah, let me just see it once. Yes, we just received a question. Yes, ma'am. Are mediators allowed to show emotions while the proceedings are going on, just in the case of other clients, or they have to act according to the code of conduct?
Well, I give my answer. Justice Sarin may have a different view. You see, mediator is a human being. If I say that they have no feelings, it will be wrong. As a judge, I know I had my feelings. There was a case of a 4-year-old child who was a rape victim and recovered from the rapist after a year. And, you know, in the chamber, I used to read the medical report and I used to literally cry. But then in the court, well, I was firm. I did not show any emotions. Nobody knew how I felt a little while back when I was reading the medical report. The mediator will have feelings, but he does not have the option to display his emotions. he will use the emotions of the parties in the mediation. You know, the emotions, he will keep the goings under his control. He has to be in control of the proceedings. He will not allow the shouting to go beyond a limit. He will not allow crying to go beyond a limit, but he will allow the parties to express their anger or whatever emotions they have, but with the idea of using these emotions in the process of reconciliation. As I said, the man was crying, the woman was consoling. It cannot be, that kind of a total dispassionate proceeding. Passions are cause, and passions will be the medicine for resolution of the disease. So passions are very important. They must be allowed to come out and they can be used by the mediator. But so far as the mediator himself is concerned, he must keep his own passions within his own chest.
Sure. The last
Justice Sarin has something to add.
I would
yes.
agree with Manjuji when she says mediator has the obligation not to show his emotion. And she is right. You are a human being. You will feel strongly about any issue, but yet you are enjoined to keep your emotions in check and not to express them. But then there are people, I think I count myself in one of them, even if you don't say a word, your facial expression shows something at times. So that you may or may not be able to control, right? But at the same time, some of these things, Manju ji, आप जब ये बात कर रहे थे, मुझे एक बड़ा पुराना केस याद आ गया. There was a leading lawyer. There was a petition for custody of children, and his wife was there, and custody was being denied. So he had said that, look, I have not met my daughters for so long. So I had said, all right, I had ordered a chamber meeting. As a judge of the High Court at that time, the matter had come in revision. So the lawyer came in, and at times it is unfortunate. You know, this is something where parents forget all maturity, see what is in the welfare of the children. You know, the mother had coached the child so badly, influenced it, that the two girls, they were about 11 and 9 years old. The moment the father entered, she started saying, I feel like puking. I want to vomit. I don't want to see him. Now, immediately I saw through it. I said, yeah, this is nonsense, what she is doing. You know, so I said, what's wrong with you? She said, sir, I can't see him. I hate him. So I said, we'll talk about you, why you hate him. And she rushed to the toilet, saying, my own chamber's toilet, to puke as if. So I said, all right, these people have to be handled with firmness. I said, call for Dr. Gandhi. He was the medical officer. I said, we'll get you an injection and medicine. You are unwell. But you will come again after 2 days for a meeting. So then I told the mother to go out. After some time, she had stabilized. Then I talked to the children. I said, what is your problem? It was after half an hour, but they persisted. In the second or the third meeting, they agreed to meet the father. So at times it is the poisoning of the children also by irresponsible parents. And you must have come across many such cases, which renders life miserable for them.
May I say something on this?
Yes, sir.
Yeah. You know, besides the obligation of a mediator to look neutral, my own little experience also shows that the maxim that justice has to be done, not only be done, but seen to be done, it applies to mediator more than anybody else, that not only you have to be neutral, you have to appear neutral at all times.
Correct.
The moment your facial expression says that you have made up your mind, so you lose the faith of the other party altogether. Okay, oh, look, this judge has already decided
Sir,
in the favor.
one correction, Dr. Qureshi.
Yeah.
Mediator cannot make up his mind. Mediator does not give a solution. Mediator only suggests a solution. He is not taking a decision on anything.
Yeah.
Mediator only leads the parties on to decide. That is the fundamental of mediation. So my making up a mind does not matter. It is the party who has to agree to it. This is the fundamental of mediation.
No, fair enough. All I was saying that
So unless if you have a party which says, sorry, you are being unfair, you will try to tell him, all right, we'll meet again. And next meeting, you will try to tell him how this is not unfair. These are the options. You consider that. These are the other possibilities. If he sees reason, fine. But if they say, no, I am not willing, then ultimately, when you can't resolve, you have a session for resolving the impasse. If you can't resolve it, you will submit a failure report. So that is the essential difference. A mediator only has to keep his expression neutrality so that parties gain confidence in him. That is the objective. There's a slight difference in that. I hope, sir, I have made this point. Thank you.
Sir, ma'am, if you may allow, can we take the last question of the session? We have one in the chat box.
Yes, yes.
Yeah. Is it right and high time in India for prenuptial agreements?
What?
Prenuptial agreements.
Prenuptial agreement. Manjuji.
Yeah.
Well, I don't think this is in vogue. There may be movies and TV shows where they are trying to show that they are ahead of time, saying that there can be a prenuptial agreement, even amongst Muslims who treat, according to even their law, it's more of a contract than a sacrament. In real practice, hardly anything like any negotiation takes place. Even the mere amount is just by way of courtesy, anything they write, the smallest possible thing, even there, that rationality doesn't go. I don't know what this prenuptial thing has not set in India at all.
Okay. Okay, thank you so much, ma'am. Thank you so much, sir, for answering all our doubts and queries. We are very fortunate that we got the opportunity to learn from your experiences as a mediator and judge. Thank you for highlighting and explaining the importance of mediation in family matters and how it helps in resolving deeply rooted issues and disputes, highlighting the difference between mediation and conciliation and important qualities a mediator shall have, like integrity, impartiality, and ingenuity. Now, I would request Professor Dr. Asha Verma, ma'am, Dean, IILM Law School, to give away the vote of thanks. Ma'am, please.
Thank you, Professor Laurie. Joseph Greenbaum has said, an ounce of mediation is worth a pound of arbitration and a ton of litigation. Good afternoon, Honorable Justice Mr. Manmohan Sarin, sir, Honorable Justice Manju Goel, ma'am, Honorable Chancellor Dr. S.Y. Qureshi, sir, respected Vice Chancellor IILM University, my learned colleagues and esteemed participants of the workshop. Expressing vote of thanks is always the most challenging task, especially when there are two brilliant speakers deliberating on a thought-provoking topic whose knowledge, wisdom, and expertise does not need any introduction. Sir and ma'am, you both are an institution in yourself, an ocean of knowledge and experiences. In fact, it is our privilege to give vote of thanks to such remarkable personalities. Disputes are a prominent part of everyone's life, which may arise in any personal or commercial association. There is nothing wrong in having a dispute, but what is important is how the parties handle that dispute. There can be two modes of addressing a dispute: litigation or mediation. The workshop was conducted with the objective to enlighten the participants about the fundamental of arbitration and mediation. It addressed the complications and technicalities involved in the process of arbitration and mediation in India. After listening to both the speakers, my understanding is that India is preparing to come ahead with its new law on mediation, which will help in facilitating the development of settling of disputes through mediation. Seeing the number of pendency cases in India, the time has come to realize the utility of mediation to be used as an effective tool to resolve the complex disputes like property, family, civil, and commercial. Who is not aware of the role played by Justice Manmohan Sarin sir in setting up the Delhi High Court Mediation and Conciliation Center and successfully training over 350 mediators? He has been rightly awarded for his outstanding contribution in the establishment and functioning of the Delhi High Court Mediation Center. It is an honor to have such a distinguished personality to discuss the various types of mediation in India, different styles of mediators, and the process involved in mediation. Thank you so much, sir, for enlightening us with your brilliant session. Hon'ble Justice Manju Goel, ma'am, your profound experience as one of the panel arbitrators of the Delhi International Arbitration Center and a master mediator on the panel of Center for Effective Dispute Resolution, London, makes us realize how fortunate we are to have you to share your views on such a relevant topic. Thank you, ma'am, for providing your insights on this wonderful topic. Let me tell you, sir and ma'am, that we really enjoyed all the live examples which you gave through Abhiman, Bawarchi movie, or being St. Valentine's bench. I believe this workshop will be a great step for all of us to understand the significance of resolution of disputes by mediation and its role in family and matrimonial disputes. This workshop is undoubtedly an eye-opener, providing insights to improve the skills of conducting mediation to the mediation professionals, as well as being useful as an advocacy program to the law students. My special thanks to our Chancellor, Dr. S.Y. Qureshi sir, who has always been a strong pillar and a constant support for the IILM family. Sir, we wish and pray for your good health and happiness always. Let me also acknowledge the fact that we could sense Diwali vibes with your mentioning about Tombola. I extend my gratitude to the management and the Vice Chancellor, Professor Dr. Sujata Shahi, for their persistent motivation and encouragement. I am also thankful to Mr. Sanjay Subarna, Mr. Vikram Sharma, Mr. Rajan Sharma, and my learned colleagues from law school for their sincere efforts and commitment in making this workshop a great success. My special thanks to Dr. Misha Behmani and Professor Lori, conveners of this webinar. Last but not the least, my gratitude to all the participants for their active participation and in making this workshop a success. On behalf of IILM Law School, I wish you all good health, success, and happiness. Please take care and stay safe. Once again, thank you, everyone.
Thank you.